I am that living soul allowed to use that? Yes, I am that soul. Sure, yeah, sure. Sure, yep, yes.
Are you David?
I feel really coerced right now. Thank you, I appreciate that.
I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you.
Today's video takes us inside a courtroom where things quickly take a serious turn. A man walks in and openly refuses to acknowledge the authority of the court. Right from the start, his actions show he has no intention of following proper conduct. His behavior is disruptive and quickly draws attention, but the judge doesn't let it slide. She stays calm, focused, and firmly steps in to take control of the situation. Her actions make it clear. The courtroom has rules, and anyone who breaks them will face the consequences. Cases like this are becoming more common, and each one puts the justice system to the test. Watching how judges respond in these moments can be eye-opening. What's your take? Are judges doing the right thing in situations like this? Let us know in the comments. And if you're interested in real courtroom moments where the law is put to the test, make sure to like this video and subscribe. It helps us bring more of these powerful stories to you. Let's take a closer look at what really happened in this intense courtroom moment. School of Arrington changed the moment the judge said bench warrant. Up until that point, the defendant had been acting arrogant and dismissive, like none of it mattered.
That is the person that I was given to use in this life. And that proper style is upper-lower case in accordance with SPR 89363, which is a court order to bring the full faith and credit.
I'm going to speak one more time, and then I'm going to allow a response. The answer is either going to be yes or no, and the answer to that question will determine whether or not you're involved in this hearing or not. But I don't allow ridiculous comments to be made, and I don't allow litigants to control the method of this court proceeding. Instead, I ask simple identifying questions because I've just called a case, and the case is called Katrina Thompson versus David Thompson. If the answer to the question I'm about to ask is yes, you're going to be entitled to proceed and be heard in this case. If the answer to the question I'm about to answer is no, you're not associated with this case and you won't be able to be heard. So the answer to the question is, are you David Glenn Thompson?
I am that living soul allowed to use that? Yes, I am that soul.
Mr. Thompson, it's either a yes or no, or you're not going to be involved in the hearing. Let me take it a step further and let you know what happens if you are not David Glenn Thompson. My next question will be, is there any other David Glenn Thompson in the courtroom or otherwise? If I hear the answer to that question, no, it's likely that the court will issue a bench warrant for non-appearance. So it's your last chance to tell me.
Sure, yep. Yes.
Are you David?
I feel really coerced right now. Thank you. I appreciate it.
But as soon as those two words were spoken, his entire attitude shifted. You could see it on his face. The confidence vanished and panic set in. What really stood out was how fast his tough talk disappeared once real consequences came into play. All the odd arguments and loud remarks, gone. He went quiet and fear took over. It just goes to show when people try to challenge the system without truly understanding the risks. It often falls apart once real authority steps in. You have to wonder, did he even realize what a bench warrant actually means? Simply put, it's a warning that the court is done being patient. It usually leads to an arrest, and it means accountability is no longer optional. And judging by his reaction, that message hit hard. So, what's your take? Was this someone trying to dodge the law, or could there be something more going on? His behavior seems so disconnected, it's tough to know what was really behind it. School let. Spi real. His friend can forget about getting that bond money back. It's gone. Honestly,
a straightforward job to proceed with. If you make that job difficult or impossible, I'm going to simply remove you from the hearing because I don't need to hear ridiculous commentary from you. So when I ask you if your name is what you're listed as on this docket and you tell me you feel coerced, I respond by indicating this. You can participate in this hearing if you're reasonable. If you're not reasonable, I'm going to remove you from the hearing. Am I clear?
Well, I do apologize. You're very clear. I'm just trying to correct errors upon your record.
This record, again, Mr. Thompson, is clear. And it will be more clear if you let me proceed further past what should be fairly innocuous, which is whether or not you're a named party. Now that we've gotten past that rather innocuous, fairly clear point, the next really clear point is this. You're here today, Mr. Thompson, because there's an allegation that you've not been paid to support as ordered by the court. If you're found to have not been making reasonable payments out of your available income, the court could hold you in contempt, and contempt is punishable by potential jail. In this case, we're also here to address a bond that you had previously posted. So, when you posted a bond, I ordered that a hearing would be set today. When I set that hearing, it's to address several things. Number one is to address the issue of contempt and whether or not I should forfeit the bond that you previously posted. The order specifically indicated to you why we're here, but because there appears to be difficulty in you understanding that, I'm going to go through it. Defendant is required under the terms of that written order that you got a copy of to show cause why you should not be held in contempt for failure to comply with the court's order. If you fail to appear, you can be found in contempt and a bench warrant can be issued. If contempt is found, the court can apply any enforcement remedy allowed under the law. The bench warrant is discharged. So again, that's the requirement of the prior order. It enunciated clearly that you were going to appear here on December 5th, and I'm glad that you're present to be able to address those issues. So Ms. Spillane, let's start with the bond. From the friend of the court standpoint, are you asking the bond to be applied towards any outstanding arrearages?
Yes, sir, we are.
Mr. Thompson, did you hear the suggestion by the friend of the court?
I did, and unfortunately, I did not put the bond up. A friend of mine put that up. I'd prefer it go back to them.
I didn't even think people who followed this sovereign citizen idea used actual cash. I figured they stayed off the grid, bartered, or lived outside the system since they reject so much of it. And imagine loaning money to someone like this, knowing he's going to walk into court and claim the law doesn't apply to him. That should be a huge warning sign right there. Oh, and the argument about names being written in all capital letters. We've all seen that one play out in court before, and it never holds up. It's one of those go-to lines that always fails, honestly. Even if this guy were a close relative, my own Sunai still wouldn't give him a dime. It's just not worth the risk. But anyway, let's get back to what actually happened in court. This point, it's clear this man needs to stop wasting time and accept the court's ruling. And seriously, what is that piece of...
Well, the bond is required by statute, Mr. Thompson, and the reason it's required is because when you have outstanding arrears, the law says that if I issue a failure to appear bench warrant, as I did in this case, that I have a statutory duty to impose a bond in the amount of 25% of the outstanding arrears or higher based upon my determination. So the amount of the bond that was posted on your behalf is going to be ordered to be forfeited towards the outstanding fines and outstanding child support arrearage. I understand your request, but I'm also confident that the person who posted bond in this child support related matter is, or should be aware of the fact that when posted, it could be utilized for those purposes. So I note your objection, but I rule otherwise in order that the bond that was posted will be forfeited towards the ongoing support obligation and or any arrearages. Once that's done, Ms. Spillane, can you tell me in general, what is the outstanding arrears, if there are any, and what is the outstanding monthly support obligation?
Your Honor, this is an arrears only case. Once that bond payment is credited to his account, the total balance would be $14,833.05.
And does friend of the court have any suggestion on what we should do outside of having the bond forfeited as I've ordered already?
We would like to refer the defendant to the referee to monitor payments going forward.
Mr. Thompson, did you wish to be heard on that suggestion by the friend of the court?
I don't even know what to say. I don't really feel that it matters what I say. You just do what you want. So, I mean, I'm looking at court orders in front of me. I'm looking at House Resolution number 10 saying, you can't ask for money because of the bankruptcy. I don't even believe this is an actual Article 3 court. But hey, here we are. And I'd like to know what happened to the promissory note that was sent in 2017 for $20,000 gold dollars equivalent, registered mail to Clerk Divider, I think it is, and why that wasn't credited to the account, since that would be a securities under these laws here.
So the court would note that I've exercised my discretion to mute Mr. Thompson. I'm going to do my best to explain why. This court proceeding has started difficult. It appears to be proceeding difficult, but it's really not a difficult understanding or case to understand in terms of the background. The background is that years ago, this case was instituted. It's a 2017 case number. It was instituted as a support matter. As the Ms. Blaine just indicated, this is a support arrears only matter, which means there's no longer any support that's currently charging, but there are outstanding arrears. Arrears means, of course, that there was a prior court order, and that court order was for Mr. Thompson to pay support. Mr. Thompson either did challenge that and was found not to have a legal challenge to that amount, or he didn't challenge it. And either way, the amounts have been, for years, been determined to have been owed. The amounts have not been paid, however. And even after this $5,600 bond has now been forfeited, the total of arrears are $14,833.05. That's not an insignificant amount. When pressed on that issue or questioned if he wanted to be heard, rather than be heard on what the friend of the court issued, which is a fairly, I would say, insignificant request to have the payments going forward monitored through a referee process, Mr. Thompson chose instead to bring up things that have nothing to do with this case. For example, I think, rather oddball claim that this is not an Article III court, or things referencing a surety contract, or other words that, although they seem quasi-legal, don't bear any particular relation to this case.
The paper he keeps waving around like it has legal weight. It's probably just another one of those unofficial documents claiming the court isn't valid under Article 3s. If that somehow makes the whole process disappear, you can almost guess what he'll say next. Your Honor, you don't have jurisdiction over me. That line has been used again and again, and it never changes the outcome. That's just not how the legal system works. Jurisdiction isn't something you can deny just because you don't like what's happening. It's not optional, it's the law. But this does raise an important question. What should the courts do when someone shows up and refuses to follow even the most basic legal rules? This kind of thinking seems to be spreading, and it's becoming harder for the justice system to deal with. So what's the right move? Should the response be tougher? Or is it better to focus on helping people understand the law? Share your thoughts in the comments. Now. Let's head back to the courtroom and see how the judge handles what happens next. School Bofer, we wrap up. Let's revisit something important because this defendant's behavior was far from normal.
And so the court is left with the suggestion of the friend of the court on what appears to be a fairly innocuous arrears only matter. And I keep saying fairly innocuous to the court. This is not a difficult factual determination. It's not a difficult legal determination. An order was apparently in place. It ordered Mr. Thompson to pay. He's not done so. Arrears are in the nature of almost $15,000 after the bond was applied, and yet there's claims about promissory notes, and other words that I've heard but don't understand how they have any relationship to this case. And I'm quite confident on the record that's been made so far, if I allowed Mr. Thompson to be heard further, I would become more confused, not less. And so it's important for me to note that every opportunity is given to litigants to be heard. Those limitations, some limitations on that right to be heard, are present in this case, and that is, I allow litigants to be heard if it's responsive to the question set forth. If it's not responsive or relevant to the question set forth, I don't find it helpful. And I wouldn't find it helpful if the friend of the court offered things that weren't relevant to the issues at hand either. So again, the court has exercised its discretion to bar any further oral argument by Mr. Thompson. Instead, I'm going to follow the suggestion of the friend of the court. I'm going to refer this case to the referee docket for continued maintaining and watching over whether or not these payments are made going forward. I will, of course, maintain jurisdiction over this court, over this case. I'm simply referring this case to the referee for further proceedings, and I'll also sign that order once it's presented by the friend of the court, ordering that the bond that was posted on Mr. Thompson's behalf is forfeited towards the outstanding arrears only in this matter. Do you have any questions, Ms. Blaine, on this case?
No, sir.
All right, thank you. The court is recess on this matter then.
Normal. He spent the hearing pacing around and acting like he had some secret proof that the court wasn't real. At times it felt like he truly believed he was in some made-up courtroom of his own. And then there's the fact that he never turned on his camera, not even once. That's a real concern. In a remote hearing, the very least you expect is to see the person involved. It's about showing respect and taking the process seriously. What's odd is that the judge didn't mention it, even though the entire situation was clearly unusual. Maybe that's one of the downsides of virtual courtrooms. But honestly, in cases like this, maybe it's time for a rule. If someone starts pushing extreme legal claims or denies the court's authority, they should be required to appear in person right away. Letting it all play out over a screen only makes it harder to manage. Everything about this man's behavior raised serious questions. It almost felt like he was acting out some personal protest against the legal system, ignoring how things actually work. And here's the strange part. People who claim to reject the system still rely on it every day for roads, emergency services, and even their right to a fair trial. Judges and court staff are dealing with this more and more. And it really makes you think, was this man simply out of touch with reality? Or was there a deeper reason behind it all? Was it confusion, a strategy, or just complete disregard for the law? Let us know your thoughts in the comments. And if you enjoy these deep dives into real courtroom moments, don't forget to like this video and subscribe for more. Thanks for watching. We'll see you in the next one.